Number 7, gee, doc, this is a never enough case. Never enough. No matter what evidence you provide, you've got objective evidence, you've got an MRI, you've got an EMG, you've got a nerve conduction study. You've got all the objective evidence that we can put up on the board and show the jury. The carrier is going to minimize, routinize, rationalize, and then capitalize for their own financial gain. You say it's a 5-millimeter herniation. The carrier says half the population's walking around with degenerative problems just like you. You're just not somebody that works hard enough. So you say objective. The carrier says it's not objective enough. You say I've got subjective complaints of pain. The carrier says, gee, we can't measure pain. You get medical tests. They want more tests. You got treatment. They say not enough treatment. Too many tests, too little tests. Too much medication, too little medication. It's never, never, never enough. So don't be surprised in your disability case where you go to a friend, a colleague, a trusted medical, terrific doctor in the community that the carrier says, oh, you went to your buddy, or oh, you went to an advocate. Isn't that interesting? Who should we go to when we have problems? Shouldn't it be a friend, a colleague, somebody that's trusted in the community? So be careful when the carrier comes with, it's never enough. 8, 8, 8. One of the worst defenses that will cripple any medical professional is they try to ERISA-size you. E-R-I-S-A, ERISA, the Employment Retirement Income Security Act. Doctors and medical professionals always say to me, Frank, how does ERISA apply to my individual disability policy? I bought it from an agent or I bought it from a broker. Didn't have anything to do with my employment. I bought it directly. It's individual. Well, think back. Did you get it as part of a list bill? Did you and another doctor or another medical professional all buy the disability insurance at the same time? Did you get a discount? Because if so, you're covered under ERISA. My acronym, everything rotten invented since Adam. There's no punishment damages under ERISA. And they can delay, and despicably, evilly deny your claim. And there's no extra damages. Lose your credit, lose your surgery center, mommy has to sell her wedding ring, the kids come out of school, no way, under ERISA, not recoverable. And all you have to do is take a look at your policy. Does it say list billing on it in the application? Do you have a salary allotment rider attached to your policy? Did your corporation pay any of the premiums for your disability insurance? If so, the carrier is going to try and ERISA-size you. And if you don't appeal timely an ERISA claim or a claim that they say is governed by ERISA, you can never later appeal. So if you see ERISA in your denial letter or you see ERISA raised anywhere, whether you see it or you don't see it, you need top insurance help to evaluate whether you're going to get ERISA-sized. Carrier defense number 9, financial gain. The carrier's going to come back, look at what we applied for, and look today at what we're earning just in front of our disability. Not fair when it comes to a medical professional. You may have had to hand off those surgeries to an underling because you couldn't stand or bend or stoop or have that sustained concentration. You may have been fighting this for 2 years before you filed the claim. That's why it's important to get some free help so you can look backwards in time. Maybe you were partial. Maybe you were total. Maybe you were both. But one thing for sure, you probably weren't enjoying any financial gain. The thing I always ask my doctors and medical professionals, chiropractors, dentists, oral surgeons, I said, wait a second. Did your insurance company 5 years ago call you up before you paid your premium and say, dear doc, how much you making this year? Want to adjust down your premium? Why is it that only at the end, when we're on claim, does the carrier then throw it in our face that we're not earning as much as when we initially applied? Financial gain, number 9, get some help. Number 10, no matter what you say, if you say total, they say partial. If you say partial, they say not at all. So you need some help in terms of evaluating when you're totally disabled. Your policy doesn't require you to be in a state of complete helplessness. You don't have to be a ventilator-dependent quad to be totally disabled. It's the important, the material, the substantial duties in time spent and money earned that we look at when we frame a total disability or a partial disability claim. It's not an exact science, and you usually need some help looking back at CPT coding or looking back at the type of procedures and how much money you earned from them to be able to know whether you're total or whether you're partial. And boy, if you're in your 60s and you've got a life contract, you've got to be totally disabled before your 65th birthday to get that life contract benefit. So get some help before you file a claim form. You need help to be able to understand the policy terms. Make sure these top 10 defenses don't come back and haunt you. And get a familiarity for the claim process and what the carrier is going to throw at you. That's why I provide that advice for free. Look at big picture. Look at the claim. Look back at the taxes. Look at the medicine. Look at the issues and try and help you before you run into a problem. That way you bulletproof the claim and you get paid. And you got the advice for free from the top insurance lawyer in the country. That's what we do at Darras Law.